Hi, this is about Chapter 7, Bulk Sales Act and about 2002. So in this section, we're talk about outline the various consideration, special consideration, and necessary documents when listing a business for sale. Briefly identify key issues to consider in the sale of a business, particularly concerning financing, and we'll discuss key provisions relating to agreement of purchase and sale, business in lease premises under the Bulk Sales Act, identify and describe requirements of a Bulk Sales Act concerning trade creditor protection and procedures that must be followed, describe selected taxation issues that arise in the sale of a business that warrant independent professional advice, and detailed requirements to about 2002, which including the use of sale of business affidavit in complying with those requirements. So let's go with the details here in terms of listing of a business. As with any specialty area, real estate practitioners must understand unique requirements regarding the type of business being marketed. With a business, various documents and special considerations also arise. The sum of all documents available to a potential buyer is normally referred to as the documentation package. Business shared assets. A vital factor in in listing a business is establishing whether the shares of the business or assets are to be sold. If the shares of any corporation are being sold, the buyer assumes all assets and liabilities. He or she will have the benefit and use of such items as the company name, copyright, leases, and real estate unless otherwise agreed. If only assets are being sold, the seller normally assumes responsibility of any existing debt, that is account payable, but retaining all the account receivables. The buyer acquires the remaining assets such as equipment, inventory, and the goodwill. Tax implication arises from either approaches, and tax position of a buyer and seller can be complex. The listing salesperson is strongly advised to confirm that the buyer and seller have consulted accountants regarding such matters. Financial statements. The balance sheet statement of assets and liabilities as of last year of the fiscal year other business should be obtained for at least 3 years of operation. Ideally, balance sheets are obtained from the seller's accountant and will be prepared for small business as unaudited statements under used in the preparation of income tax returns. The profit or loss statement, that statement of revenue and expenses, should also be obtained for the same period or as many years as available. The extent of historical financial documentation often translates directly to a more accurate analysis of business trends and a more sellable listing. In Ontario, the REVA requires that the financial statement be delivered to the buyer or that the buyer waives compliance with this requirement. Standard forms have been developed for use. Fixtures and chattels. Details of fixtures and chattels are needed. A list of items included in the sale. A list of items not included in the sale. REVA 2002 does not specifically require a list of included fixtures or chattels, but only those that are excluded. If various fixtures and chattels are not excluded, Rabbi states that all such items are deemed to be included. As a point of prudence, constantly salesperson obtain both the lists to avoid any confusion. Rabbi wording in is specific regarding the scope of this list. A list of all fixtures, goods, chattels, right, and other assets. Lease. If the business premises is leased and not owned by the seller, a copy of the lease is required. The content of the lease can directly affect both the value of the business and its marketability. The buyers will be particularly concerned with whether the lease can be assigned, under what condition can the assignment occur, the remaining terms of the lease, including any provisions for it to benefit the terms, benefit, and restrictions contained in the lease. Whereas a relatively short possession period remains, the buyer may require assurance that a satisfactory extension of the lease agreement can be arranged and require a condition to that effect in the agreement. Franchisee agreement. If the business operation under a franchise is if the one business operates under a franchise arrangement, a copy of the relevant agreement must be included in the documentation page. Conditions can exist within such document that affect or possibly nullify the sale. For example, the franchisor normally Normally charges on ongoing royalty fees for the benefit accruing from the franchise affiliation. In most retail franchises, an advertising fee is also levied for regional or national promotion programs. The franchisee may further require approval of any franchisee along with the appropriate condition included in any offer, and may also require that the new owner undertake a specific product training license. Detail of any operating license must be obtained from the seller and inserted in the documentation package. Depending on the circumstance, information about how the buyer shall obtain or have the license transferred is also required. A prime example would involve a licensed restaurant under the Liquor Control Board of Ontario. The license is awarded to the owner who operates the restaurant and not to the premises. Any transfer of business ownership must be accompanied by the transfer of that liquor license, subject to the approval to the new proprietor. Financing option. Buyer rarely pay all cash for the businesses, and consequently seller financing is commonly encountered. So again, with regard to the financing, buyers rarely pay all cash for a business, and consequently seller financing is commonly encountered, as well as additional outside financing. In either or both instances, details should be clearly set out concerning the range of the financing options available, as these can translate directly into an improved marketing position. For example, the buyer may have a 30% down payment based on the purchase price, but is unable to secure fund elsewhere. The balance of the purchase price can be financed by seller, take-back mortgage, and the assets of the business will be used as the security. An earnout can be used to pay off the mortgage. The terms of the earnout are established to suit the parties. The buyer is able to pay the balance of the purchase price with cash flows, while the seller concludes the sale by offering a favorable and manageable financing option. Buyer may also ask the seller to remain as a consultant for a predetermined salary or a fee. The buyer benefits from the seller's experience and knowledge, while the seller can ensure the continued success of the business and the payment of the outstanding balance. Additional document. The range of documents is dictated by the type of sale, as was a share, the specific business involved, and the creativity of the salesperson providing a detailed offering to the marketplace. As with all commercial offerings, the better the documentation package, the more effective the overall marketing program, the better the prospect of the sale. Additional documents might include details of any equipment lease, along with the relevant terms and conditions, copies of any notes, business contracts, unique agreements that affect the business and will be assigned to the buyer, like a franchisee agreement, employment contract, licensing agreement, and, and the client contracts. Demographic, economic, and other statistical information in support of the business, such as trend in the related retail and traffic count, photographs of the business, both interior, exterior, including trade fixtures, copies of any appraisals completed on chattels and fixtures included in the sale, and selected tax return information relating to the business. Now coming to the sale of so to recap, during the listing of a business, we need to identify if the business share or the assets are being acquired. We need the financial statement for the last 3 years. We need the fixtures and chattels which are excluded. A copy of the lease, whether the lease can be is always required if the business is operating in a lease premises, because unless the lease can be assigned, the the buyer cannot use the business premises. Franchisee agreement. A copy of the franchisee agreement is required in case of any licenses. We need to understand if the licenses can be assigned. Financing options, seller take back mortgage with the assets of the business as securities, you should be looking to. Also, the kind of earn out. Additional document includes the details of any equipment lease, copies of the notes, business contacts, unique agreements, demographics, economic and other statistical information, photographs, appraisals, and also the tax returns. Now, in case of a sale of a business, the The sale of a business requires a specialized knowledge, particularly about provincial legislation requirements that may impact the sale, including the use of the applicable forms. Prospects must be properly qualified considering the financial matters, particularly given the challenges of securing business financing. So we need to establish precisely how much actual cash or liquid assets can be applied to the purchase price, ascertain whether the buyer intends to work on a full-time basis in the business being acquired or simply purchase the enterprise as an investment, as this will have considerable bearing on selecting the appropriate type of business, determine if the business has any practical skill. I'm sorry, to determine if the buyer has any practical skill in the business under consideration, obtain permission to conduct a credit check. A buyer net worth statement can be advantageous in assisting the seller in making a decision about a particular offer. Since many businesses involve seller financing, the buyer willingness to enter into a personal guarantee should be established at the onset. Lastly, evaluate the buyer's attitude, temperament, experience, and aspirations. Often businesses look attractive from an investment perspective but are not suited to a particular buyer because of the amount of annual labor needed, uh, um, the number of hours required, range of hours demanded, and the necessity of the specific skill. By narrowing the field, both buyers and sellers can work more productively in finding the right fit. With regards to agreement of purchase and sale, the agreement of purchase and sale business in the lease premises under the Bulk Sales Act is illustrated. The form, in addition to the standard provision usual to most agreements, addresses unique items related to the business such as non-competition issues, representation of warranties by sellers concerning asset residency covenants and inventory. So, a couple of interesting clauses with regards to agreement to purchase and sale business in the lease premises under the Bulk Sales Act are the non-competition clause, covenants by the seller. So a non-competition clause will read as seller and the undersigned jointly and severally covenant not to carry on or be engaged in or concerned with either directly or indirectly in any manner whatsoever, including without limitation as a principal agent, partner, or shareholder, any business competitive with and similar to the business as presently carried on within the radius of this kilometers for the premises within the radius of 5 kilometers of the premises for X months after completion. The aforementioned covenant shall survive the completion of the transaction provided for herein. And also there are a bunch of other covenants, the seller covenants, that the assets are now and shall be at the time of completion be owned by the seller, free and clear of any encumbrance, the charges and or other person has now or shall at the time of the closing have any interest in the assets except the 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 following items. The seller is not now or shall not be at the time of completion be a non-resident person within the section 116 of the Income Tax Act. Seller is not in default of any agreement related to the business, and there are no actions, suit, or proceedings against or on the behalf of the seller pending or threatened which may affect the business, and the seller is not aware of any existing grounds on which such actions, suits, or proceedings might be commenced. That there is a good, valid, and subsisting lease of the premises for the term of this years at a monthly rental of this dollars expiring on this day of all copy of lease is attached. That they are not now and shall not be at the time of completion be any employee of the business excepting the following, all of whom will be dismissed on the minimum applicable statutory notice without further liability. The business shall be carried out in the ordinary scope. The business has been carried out in an ordinary course, and all financial statements and other information provided to the buyer are true, accurate, and correct in all matters, in all material respect, and have been prepared in accordance with generally accepted accounting principles applied on a consistent basis, and seller shall at the time of completion have no liabilities, contingents or otherwise, except as reflected therein or in the statement to be delivered pursuant to the Bulk Sales Act, none of which shall be inconsistent with the past practice or materially adverse. No expenditure shall be made out of the ordinary course of business prior to closing, and the business shall be carried on up to the time of completion as in the ordinary course, and in a commercial reasonable manner with a view to preserving the goodwill of the business. The tangible assets are now and shall be at the time of the completion be in a good condition, subject only in the case of equipment to reasonable wear and tear. Further covenant by the seller covenant to comply with Section 6 of the Retail Sales Act, to comply with the Bulk Sales Act, to deliver the buyer at or before the time of completion the written consent of the lessor to the assignment of a lease of the premises of the buyer, and to indemnify and save harmless to the buyer from and against all liabilities, claims, and demands in connection with the purchase business existing or incurred as at the time of completion and not shown on the financial statement provided to the buyer or in the statement delivered pursuant to the Bulk Sales Act or explicitly agreed or to be signed by the buyer in this agreement. So the key covenant here is that the seller covenants to deliver to the buyer at the time at or before the time of completion of the return consent at the time of completion or the return consent of the lessor to the assignment of the lease of the premises to the buyer. Buyer represents a warrant that the buyer is not now or shall not be at the completion at the time of completion be a non-eligible person within the meaning of the Investment Canada Act. Covenant by the buyer obligations to complete this transaction shall be subject to satisfaction of the following conditions. Inventory prior to the completion, either party may elect by written notice to the other of the inventory shall be physically counted after the close of the business on the day prior to the completion and is valued by the seller's cost thereof, in which the case the total purchase price shall be increased or decreased to the extent that the valuation so obtained is greater than or less than the amount set for the inventory stated above. Now coming to the Bulk Sales Act. The Bulk Sales Act is a provisional statute designed to protect the trade creditors of the seller when the sale of the stock in bulk is occurring out of the ordinary course of the seller's business. The buyer must demand and receive from the seller a sworn statement of the seller creditors. If the buyer does not comply with this act, the sale of the bulk is voidable by an action started by the creditor. The Bulk Sales Act can apply not only where the business is being sold but also to any sale where the stock is being sold in bulk. This legislation sets out a number of requirements, including but not limited to giving notices to the creditors, duties of the buyer, risks to the buyer if procedures are not followed, requirements concerning trade creditors' claim, and the amount concerning such claim. Requirements of this Act shall be reviewed in conjunction with those in the REBA 2002. The parties to this transaction shall not be aware shall be aware of the tax implication of the sale of the business. Independent professional advice is required for both buyer and seller. So to recap, the Bulk Sales Tax is a provisional statute designed to protect the trade creditors of the seller when the sale of the stock in bulk is occurring out of the ordinary course of the seller's business. The buyer must demand and receive from the seller a sworn statement of the seller creditors. If the buyer does not comply with the act, the sale of the bulk is voidable by an action started by the creditors. The Bulk Sale Acts can apply not only where the business is being sold but also to any sale where the stock is being sold in bulk. This legislation sets out the number of requirements, including but not limited to giving notices to creditors, duties to the buyer, risks to the buyer if procedures are not followed, requirements concerning trade creditors' claim and the amount concerning such claims. Requirement of this act shall be reviewed in conjunction with Rubber 2002. The parties to a transaction shall be aware of the tax implications of the sale of a business. Trade creditors protection. A seller generally can sell whatever is owned without concern for personal or trade creditors. However, to protect trade creditors of the seller, bulk sale acts requires the buyer follow certain procedures. If they fail to comply, the sale of the bulk may be voidable and the buyer may be accountable to the creditors. Not every transaction is covered by the Act. This statute only affects the sale of the stocks in bulk outside of the ordinary course of the seller's business. Stock includes real or personal property, goods, chattel, fixtures, or other defined items with which a person carries on trade or business. Some sales are exempted, including those by an estate, a trustee in bankruptcy, or a creditor realizing upon a security. A judge may make an order exempting a transaction from this act if the sale is advantageous to the seller and if it does not limit the ability to pay creditors. Procedure. Procedure pursuant to the Bulk Sales Act are best described by the way of example. A buyer may pay up to 10% of the purchase price to a seller who hold monies in trust. So to repeat, procedure pursuant to the Bulk Sales Act are best described by the way of an example. A buyer may pay up to 10% of the purchase price to the seller who owed monies in trust. The buyer must demand and receive from seller a sworn statement of the seller creditor in a form prescribed by the Act. This form shows the names and address of the creditors, the amount owing, and any security. The buyer can complete the transaction directly with the seller if the statement shows that the secured trade creditors' claim do not exceed $2,500 and the unsecured trade creditors' claim do not exceed $2,500. The trade creditors' claim have been paid in full, or the adequate provision is made for payment in full to the trade creditors out of the sale proceeds. This may be accompanied the purchaser by the purchaser making checks payable directly to all of the creditors, or by the undertaking by the seller's solicitor to pay all trade creditors except those that may have signed a prescribed waiver. A, a trustee may be appointed by the seller with the approval of the unsecured trade creditors, accounting for at least 60% of the number and the value of the claim that exceeds $50. If such consent is not obtained, a judge can appoint a trustee. The trustee receives the proceeds of the sale and distributes them to all creditors as if the seller went bankrupt. A schedule of the fees of the trustees set out in the Act. In the 5 days of the completion of the sale, an affidavit of the particular of the transaction and the required form must be filed with the Ontario court where the property is located. The buyer can obtain the court order for late filing if the time period is missed. After 1 year, if all trade creditors are paid and no legal proceedings against the transaction have been commenced, the judge can make an order that the buyer need not file the documents. If the buyer does not comply with this act, the sale of the bulk is voidable by an action started by the creditors of the seller. If the sale is set aside and the buyer takes possession of the stock in bulk, the buyer is personally liable to account to the creditors for its value. To put it simply, the buyer must pay with the stock twice. First, when the seller is paid, and second, when held accountable by the creditors. The Ministry of or the Attorney General is responsible for the Bulk Sales Act. As mentioned, the Bulk Sales Act applies if the inventory is involved in the sale of the business and it's designed to protect creditors while imposing certain obligation to the buyer. Practitioners should be aware that the legislation relates only to the situation where a sale of stock in bulk occurs outside the usual course of business or the trade of the seller and would therefore likely apply to the sale of business. As a matter of fact, Act applies not only when the business is being sold, but also to any sale where the stock is being sold in bulk. Under normal circumstances, the registrant will not have any direct participation in the actual proceedings of the sale after the acceptance of the offer, as this normally falls to the lawyer for the seller and the buyer. However, the agreement must stipulate that the sale is made under the Bulk Sales Act. A 10% limit on the amount of deposit applies, and these funds must be taken subject to the conditions set out in the Section 6 of the Act. The buyer may therefore receive a statement, pay the seller to the amount of the purchase price, a sum not exceeding 10% of the purchase price, which shall form part of the proceeds for the sale, which the seller shall hold in trust. For the buyer, until the completion of the sale, for the buyer until the completion of the sale or the sale is not completed, the buyer becomes entitled to repayment of it until it's repaid by the buyer. When the sale is completed and the trustee has appointed for the creditors until the sale complies with the provisions of the Bulk Sales Act. REBA 2002. So under REBA 2002, a business for the purpose of the act is an undertaking carried out for gain or profit, and includes any interest or in any such undertaking. Provisions concerning the purchase of a business have not been changed significantly from the previous act, but all practitioners should carefully review legislative requirements. Buyer, buyer must receive, prior to the binding agreement, a profit or loss statement for the last 12 weeks, and since the business was acquired by the person disposing it. So again, REBA, or Real Estate, the Real Estate and Business Broker Act 2002, has provisions concerning the purchase of a business that has not been changed significantly since the previous act. So there are three conditions that must be satisfied. So the buyer must receive, prior to a binding agreement, a profit and loss statement for the last 12 months or since the business was acquired by the person disposing of it, a statement of assets and liabilities, a list of items that are not included. The first and the second requirements do not apply if the buyer signs a statement attesting to have received and read a statement from the person disposing of the business as to the various matters relating to that business. So again, if the terms and conditions under which the person is selling the business possesses the or so so in case the a buyer signs a statement attesting to having received and read a statement from the person disposing of the business as to the various matters related to the business, that the terms and conditions under which the person selling the business possesses the business premises, terms and conditions relating to any sublet of the premises, a statement that the seller selling the business has provided all books of account in his possession, or has refused to do so, or has no books. So again, the requirement to for a profit and loss statement for the past 12 months, or the statement of assets and liability, that is that can be that will not apply if the buyer signs a statement attesting to have received or read a statement from the seller about the terms and conditions under which the business under which the business possesses the business premises, terms and conditions relating to any sublet of the premises, and the statement that the person selling the business has provided all the books of account in his possession, or has refused to do so, or has no books. Now, the sale of business affidavit was form OD Form 5 and 3 was developed to assist listing brokerage and the seller of um, businesses in complying with the requirements for the Section 21 of REBA 2002. In situations where financial statement of the for the business are not delivered to the buyer, the sale of business affidavit is completed by the seller and delivered to the person acquiring the business before a binding agreement of purchase and sale is signed by the parties. So that is the key. Before a binding state agreement of purchase and sale can be signed by the parties, the 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 sale of business affidavit form must be completed by the seller and delivered to the person to the to the buyer. The form requires a declaration oath concerning who is the owner of the business, whether the business premises are leased or owned, what portion of the business premises, if any, is sublet, liabilities, if any, if there are or are not books of account for the business, an explanation of why the financial statements are not being delivered to the buyer. The bottom portion of the form contains a waiver to be completed by the buyer if he or she does not require the seller to comply with clause 1 and 2 of subsection 21.2 of REBA. So the form reads as I has like for I'm the owner, possession of the premises, who's the owner, whether the business premises are leased or owned, what portion of the business premises, if any, is sublet, liabilities, if any, if there are any books of accounts, and the bottom part contains a waiver. I think with this we are done with chapter 7. Thanks for your time. Again, if we can recap. The sale of the business involve unique requirement that must be addressed. Registrants need to prepare proper documentation package with all information necessary for a potential buyer. Make certain that the documentation package includes particulars of all leases, franchise agreement, and licenses. Business financing can be challenging. They take time to set the stage properly with the both buyer and seller. No standard form is used in Ontario for sale of business. The Ontario Form 502 is used for illustration and instruction purposes only. Carefully review all all agreement provisions, particularly concerning seller representation warranties and covenants. The Bulk Sales Act is designed to protect trade creditors, and procedures under the statute should be fully understood. Be aware of the taxation issues, particularly concerning harmonized sale tax. Number 2, to set out specific requirements regarding the provision of financial statements. In the alternative, a required affidavit is set out various particulars about the business. Number 2 also requires that a list of items not included by the sale be provided to the buyer. The sale of business affidavit form is designed to meet the requirements set out in REBA 2002. I think with this we are done with Chapter 7, Bulk Sales Act, and REBA 2002.